This is a true crime discussions channel. We speculate. This is all just speculation. Because it's true crime, it's for mature audiences only. There will be no children allowed, no exceptions. Everything on this channel falls under fair use. Please remember to like, comment, subscribe, and share. It's free.
Lord, I'm just talking away. Okay. I apologize. I thought it was unmuted, y'all. I've had a mad dash trying to get all my documents printed out for today's live because we got a document dump that is giving us a lot of insight of what Stephen Stearns is going to do in this trial. It is breaking news. I really want to take a second and thank my lovely mods who got this information to me. I'm going to share it with you here. This will be the first place you hear it if you see this. If you come and watch this live, this will be the first place that you hear it that I know of anyway. They just were printed. They were just submitted yesterday at like 4:46. So they just got here. I apologize about being muted. So yeah, I have to print them out because I can read them better that way. So it's been a mad dash because there's 6 documents and each one of them is like 6 pages. So I apologize about that. My brain is all over the place. Let me get my YouTube pulled up, and while that's coming up, I will say hey to you all. I've got some things to show you. Hey, Bad Girl, Bazard, Just G, Anders, Curious, Veronica, Mallory, Tony, good to see you. JPL, Anna, Lori Green, Angela, Ballerina, Vicky, Teresa, Jess G. I saw you became a member. So I will come pick you up on the crazy train. Hey, Glitter is forever. It's good to see you. Cozy Constellations, Mommy Moo Moo, good to see you. Petunia, Eek, Claudia, good to see you all. You guys are so awesome. I'm sure I've missed some of y'all. If you comment at the bottom and I see you, I will shout you out. You guys are so awesome. Hey, Florida girl, Jennifer Collins. Okay, so what we're going to do first is we will talk about Sheriff Lopez real quick. Miss Hio made a video last night on it, so I want to show you where this situation originated, and then we will watch the video she made on it, and then we're gonna watch a video somebody else made that I was told it was made for me, which I thought was so sweet, and I have linked that person in the description box. I am gonna warn you that the video I play after we talk about Sheriff Lopez is gonna make you cry. I'm just telling you that now. Okay, so we're going to play two 2-minute videos and then Hio's video on Sheriff Lopez. We'll go ahead and start that now so you understand this situation.
Osceola County's top law enforcement officer.
Okay, hold on just a minute. This is going to be what appears to be News Channel 9 in Orlando. So we'll go ahead and get this while I finish getting things ready for the live and continue on. Oh, let me turn on the closed captions. Thank you. Thank y'all so much for being here. Hey, Katia. I think I've got most of y'all. Okay, thank you.
Officer is now on a list that no officer wants to be on. It's called the Brady list. That's a list of officers and deputies with credibility issues that need to be disclosed in court when they're testifying. Channel 9's Nick Papantonis reports the sheriff's placement on that list comes from a high-profile case in Osceola County.
There was an apology issued, but it wasn't actually the body.
It was that moment that now has police analysts saying Osceola County put itself in the history books for the wrong reasons. Prosecutors last week placing Sheriff Marcos Lopez on their Brady list, a database of law enforcement officers that are considered unreliable and whose credibility concerns need to be disclosed to a jury that hears from them.
Now, from what I understand, the Brady list is nationwide. I've seen officers from other states be put on this list as well. From what I understand, it's a nationwide list of basically disgraced officers, if I understand correctly.
I have never seen where the top law enforcement professional was on that list.
Lopez's comments on the radio program claiming he did not post a photo of 13-year-old Madeline Soto's body to his Instagram page last winter, even after his agency apologized for it. A scathing letter from the prosecutor's office to Lopez writing about the sheriff's lack of truthfulness and accusing the agency of pulling maneuvers to limit the political damage to Lopez as it investigated its own leader.
Curious Christine, thank you so much for the super chat. Curious Christine says, thank you for the warm welcome. Sweetheart, I don't feel like I was as warm as I should have been right now because I am flustered and I forgot to come pick Jesse up on the crazy train. Jesse, thank you for becoming a member and being supportive. And Curious Christine, thank you for being so supportive. You guys are amazing. Thank you so much. I'm going to grab the crazy train that's going to arrest Jen Soto and we're going to come pick you up. That was for Jess for becoming a member. Thank you so much. And again, thank you so much, Curious Christine. That was so sweet of you. That was so sweet. Thank you, guys. Yeah, I apologize for not being as warm as usual on the welcome. I was flustered for a minute there.
Of course, the deputies are looking at this as if I did this, I would be probably fired and definitely investigated by Internal Affairs.
This does nothing to help with the trust and the integrity that you would want to have in the law enforcement profession.
Dr. Randy Nelson works with officers and says most agencies have 0 of its members on such a list. He called out Osceola County and the city of Kissimmee for what he says was a culture that kept its law enforcement professionals under the microscope.
I think it says more about that there's 66 other counties in Florida that have, where the sheriff isn't on the Brady list. And you have that one.
Nick Papantonis, Channel 9 Eyewitness News.
Neither Lopez nor his agency responded to our request for comment. The sheriff was fined for the post, which broke the law because of Soto's age.
I couldn't increase the volume on that one, unfortunately. It was really low. I tried. All right, so Hio. Oh, God, y'all. Hold on a minute. That's the video that's going to make you cry in just a minute. Woo. Hold on. I'm going to play Hio's video that she put out last night. So please go check her out. And after that, we will watch that video that started playing. I got to mute her intro. She is linked in the description box. She is my mod that comes up. So definitely check her out. She is so wonderful. This is so funny.
Against you in the court of law, you have the right to talk to a lawyer and have the present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questionings if you wish. All right. You good, dude?
Hello and welcome to the channel.
That dude is on a plane of existence that we cannot see, y'all. He is good. He is so good in his state of mind. He is on a whole nother level. I dropped the link if anybody wants to come up. Hey, Abellis, it's good to see you, love. And Miss MB, Elise, I have no idea how to say your name. Elisa Tita, thank you for being here. Jenna Cook, thank you for being here. So again, this is from Hio, my lovely mod. She is linked in the description box. Please go check her out.
Osceola County Sheriff Marcos Lopez making headlines once again. The state's attorney's office has officially placed Lopez on the Brady list. It's a database of law enforcement officers that are deemed untrustworthy to testify in court. This decision stems from allegations that Lopez misrepresented facts and made misleading statements, potentially impacting criminal cases. But how did we get here? Sheriff Lopez has faced multiple controversies during his tenure, including accusations of misconduct, excessive force, and now credibility issues that could jeopardize prosecutions in Osceola County.
Lord, I hope that it doesn't jeopardize Madeline's case. Cara, that was so sweet of you to gift 10 Speculation Station memberships. Oh my goodness, thank you so much. If you guys were gifted a membership, please tell Cara thank you. And I'm going to come pick y'all up for Speculation Station. Thank you so much, Cara. It looks like Christelle, Robin, MG, Stephanie, Mary, Blue, Sanderella, Courtney, JK were gifted. Yes, that's what I see. Those are our new Speculation Station members. Thank you so much. What the hell? I'm sorry. I didn't mean to say that out loud, but what are you talking about? My grandmother would let us melt cheese in coffee. We would eat the cheese and she would drink the coffee. Oh my goodness. The Mojo, if you want to become a member, there's like a little symbol down by the chat. It looks like a $sign. You can click that. Or if that doesn't work, you can like exit out of this and go to my page, like where it shows you all the lives and the videos, and click join there and it will let you. Hey, Gray Moon, I don't know if I said hey to you yet. You're so sweet, Cara. Thank you. Okay.
This latest move by the state attorney's office raises serious questions about his ability to serve effectively. Osceola County Sheriff Marcos Lopez doesn't think much of outgoing state attorney Andrew Bain's assessment that he is untrustworthy. In his first public comments about being placed on the state's Brady system, a collection of law enforcement officials deemed untrustworthy, Lopez called the action by outgoing state attorney Andrew Bain personal and political. A letter
Hey, Meandering, it's good to see you.
Bain sent to Lopez dated December 30th was made public this week that outlines Bain's issues with how Lopez handled an unfortunate situation during the investigation when 13-year-old Madeline Soto went missing and her body was found south of St. Cloud. I made this decision following my review of the Florida Department of Law Enforcement's investigation into your publication of a photograph depicting the killing of a minor victim, as well as the findings in your administrative inquiry. Bain wrote.
MB, did the I guess you didn't drink the coffee, but I would wonder if the coffee would taste like cheese, or did the cheese taste like coffee? That's really interesting. Hey Pam J. It's good to see you, love. I love melted cheese, and I love melted peanut butter. I would put peanut butter in a pan and melt it just to eat melted peanut butter, especially if you make toast with peanut butter on it. I'm getting way off subject, but I've never heard of cheese and coffee.
Wrote in the letter. A photo of the crime scene, where Soto's body was discovered on March 1st along Hickory Tree Road, briefly appeared on one of Lopez's social media accounts the next morning, among other photos of a public event. In a subsequent radio interview, Lopez denied the photo was of Soto, but after the Florida Department of Law Enforcement investigated, he claimed the photo was accidentally posted, and he issued an apology. The state filed a non-criminal public records violation, and Lopez paid a $250 fine December 18th to avoid a public court hearing. In a statement issued late Thursday afternoon.
So he accidentally released Madeline's photo it wasn't of her killing, it was of the crime scene, and he paid a $250 fine, and now evidently he is on the Brady list.
Afternoon. The sheriff's office said Lopez cited political pressure as the reason for Bain's action and felt it important to address the matter personally. This was a political gimmick by Andrew Bain, who lost an election. In between the time that Bain sent his initial letter about his concerns and the time he added me to the Brady list, there were requests for me to endorse Bain. I did not endorse him. I was subsequently added to the Brady list. I think his.
So that's interesting. The sheriff, y'all are so sweet today. Thank you. So this attorney wanted, or the person she was talking about, I just lost my train of thought, wanted to be endorsed by the sheriff. The sheriff said no, so that person put him on the Brady list, which I think is some backdoor political BS, if you ask me. That's not acceptable, but it's also not acceptable to leak the photo of a child. Abellis gifted 10 memberships. Thank you so much. If you were gifted, please tell her thank you. It looks like Sid Vicious. I have seen you somewhere, and I can't think of where I've seen you. April TN was gifted. Marion, Old One, was gifted. Stephanie, Shelley Stoned. I love that name. Lucille Balls, Bob Hobb, Teddy Burr, and KR were gifted. That's so awesome. Make sure you tell Abellis thank you. I will come pick y'all up on the crazy train. I'm going off the rails on a crazy train. Thank you so much, Abellis. That was so sweet and supportive of you. Thank you guys for the support. I don't know. I don't know why we keep getting crime scene photos of children being shared everywhere. Bob Hobb says thank you. Thank you, Bob Hobb. Yeah, and Hio said welcome in all new members. Thank you.
His decisions were personal and political. I'm sad that Andrew Bain put politics before people. I did not lie, and I will always stay focused on what really matters, fighting crime and protecting the community. Bain's harsh criticism of Lopez and the internal investigation done into the matter centered on how said investigation was actually an improper inquiry and how Lopez later lied about the photo. An investigation is warranted in that situation more than any other, Bain said in the December 30th letter. I am concerned that an inquiry was selected and done to ensure you would not be questioned under policy, since an investigation would have mandated you answering questions under oath. Regarding his denial, the photo was of the victim in the radio interview. Bain observed, when viewed in this
Hey, Edith. Good to see you, love.
proper context, it is hard to read your immediate answer as anything but an attempt to claim the photo you posted was not the victim, in an attempt to lessen your public responsibility for a violation of Florida public records laws.
Now, it was messed up. I mean, if that happened, you should have admitted it. You should have taken responsibility immediately, and you should have apologized. I do understand that it was an accident, because reading through the paperwork, he is one of the people that are called out to the scene. And of course, they have to take pictures, but I would think it would be on a different device of some sort. But then, I mean, once it happens, just like creators on YouTube should, if you mess up, you need to apologize. If it was a legitimate mistake, you apologize sincerely, and then, you take whatever punishment you get from it. I mean, you don't need to be lying about it, in my opinion.
This is particularly true when your public statement then pivots to trying to blame political rivals for discussing the photos you posted.
Hey, Natasha. Hey, Miss King of anything.
Lopez is on the long list of witnesses against Stephen Stearns, who has been charged in Madeline Soto's murder, along with another long list of child sexual assault charges. Given your status as a witness, your statements to the media could be used to impeach you pursuant to Florida statute, Bain wrote. This leaves us no choice but to include you in our Brady identification system, so defense counsel may evaluate your statements for impeachment, and, if appropriate, a court may make a determination as to their admissibility for that purpose. Bain isn't the first state attorney candidate Lopez has openly criticized. In March 2023, the sheriff asserted that former state mayor Monique Worrell wasn't aggressively prosecuting drug traffickers' cases the sheriff's office turned over to Worrell's office. While Worrell responded that Lopez's allegations were false narratives and misleading information, and a seemingly coordinated attack, Governor Ron DeSantis removed Worrell from office 5 months later. Worrell subsequently defeated Bain in the November 5th state attorney election. So what happens next? Lopez is firing back, calling the allegations politically motivated and denying any wrongdoing. The sheriff's office is expected to challenge this designation, but the damage to his reputation and his ability to lead might already be done. So do you think Sheriff Lopez can recover from this? I'd like to hear your thoughts in the comments. As always, thank you for hanging with you.
So that was what she had, and I really appreciate her doing that. She's got a lot of Sarah Boone stuff, but she's got a lot of really good stuff. I want to play this other video for you now. I'm going to warn you, this is going to make you cry. I'm just going to go ahead and let you know. You better have some tissues ready. It's sad. For whatever reason, I have to move these down. This is from Period Point Blank. She made this video, and I literally cried this morning. So, not that one. Oh, there it is. So I'm going to share it with y'all, and then we'll jump into these documents, maybe. Oh my goodness. I hate the way this playlist does this. Okay. Why? Hold on just a second. Oh, now it wants to work. Okay. Oh my God. Don't do it. Nope. My computer is being iffy. Luckily, we've got documents to look at, so. Y'all, that's a hard video to watch. I'm going to try to play it again. Yep. In full screen. Oh my goodness. Whew. That is so hard to... Whew. Good Lord, that is so hard to watch. Okay. So, whew. Now we have documents. Lots of documents. We kind of get an idea of what Stephen's plan is in all of this. Now, I have 6 documents I uploaded. I'm going to try to make sure we start at the right place and then continue. I'm trying to do it in the order they were submitted. So I think that's the last one. Hold on a minute. I know y'all can't see it. I'm going to work on getting it pulled up for you. I think this is the first one. Let me go ahead and pull this up. Nope. Oh my God. Okay, this is it.
Oh, why are we whispering?
I don't know. Am I whispering?
I don't know. You were saying, "Oh my God, why are we whispering?" Are you okay?
Oh, because I couldn't get the document pulled up. I'm trying to do them in order. Okay. Because I wanted to do them as like they were presented. Now, so this is the first one. I'm going to zoom in. Now, I played that video right before this so that we would remember why we're doing this and why we are reading these documents. It's going to be a lot of documents to read through, but it's important to read through them to understand what this POS is doing and why it's important.
What number are you doing? Which one?
The first one, the motion in limine, which I need to pull up what that means real quick.
The motion in limine?
Yeah.
Does that say 177 on it?
I don't think so. It says it's Division 12A. It says it was filed 1/30/2025 at 4:46 p.m. and 7 seconds. It's filing number 215730299.
299.
I'm going to try to pull up each thing so we understand exactly what they are saying. To the person, I don't know if you were being like coy or why you said this, but you said to go watch. You mentioned it too.
I wouldn't. There's 5 other comments. I wouldn't even.
Well, there's
not
two.
Even.
The point is, there's 2 creators you mentioned to learn how to do a live, and one of those creators doesn't even do lives. I just wanted to point that out to you. But anyway, moving on. A motion in limine regarding penalty closing arguments is a pretrial request filed by an attorney asking the court to rule that the opposing party cannot mention certain specific arguments or evidence related to sentencing during their closing arguments, essentially seeking to prevent potential prejudicial information from being presented to the jury during the penalty phase of trial. So the key points about a motion in limine regarding penalty closing arguments, the purpose is to prevent the opposing side from making arguments that could be considered unfairly prejudicial or legally inadmissible when discussing the appropriate penalty for a defendant. Pre-trial filing. This motion is typically filed before trial begins, giving the judge a chance to rule on the admissibility of specific arguments before they are made to the jury. Specificity is key. The motion should clearly identify the specific arguments or evidence that the attorney wants excluded, explaining why they are considered improper or prejudicial. And it gives example scenarios. So basically, this paper they filed is saying that something is prejudicial about the murder trial, the homicide trial. So what does Stephen Stearns and his attorney think is prejudicial about this trial? What do they not want admitted into evidence? We're going to read through it. And we,
before you start reading.
Oh, go ahead.
Let me put my glasses on here. So okay. The motion, the document, the motion in limine regarding penalty and closing arguments is this particular one, right?
Yes. I need to scroll up.
So the defense, go ahead. The defense represents the public defender's office, who is for Stephen Stearns. He's requesting that the court prohibit the prosecution from making improper statements during the penalty phase and closing arguments in his case. So the motion is it cites different examples of prosecutorial misconduct that have been previously ruled improper by the Florida Supreme Court. And so that's what they're introducing, their key arguments. So as you go down them, we can talk about them, but they've got in this particular one, they have 14 different things that they're citing as to prevent the prosecution from introducing in against prosecutorial misconduct. So I'm just trying to clarify a little bit I don't know if that helps, but we can, as we go down.
Yeah, and I appreciate you being up here because you can help me break it down a little bit better. I'm so glad you were gifted glitter. I saw that Miss O came in and a few other people as well. Hey, Darlene. Okay, so we'll start reading this. So this states that Stephen Michael Stearns is the defendant. Motion in limine regarding penalty closing arguments. The defendant, Stephen Stearns, I'm going to try to make sure that I stay with you guys on this, moves the court in limine for a ruling directing the state to refrain from making improper comments in penalty phase closing argument. As the Florida Supreme Court has stated, improper prosecutorial comments in closing arguments may be grounds for disciplinary sanctions. We are deeply disturbed as a court by continuing violations of prosecutorial duty, propriety, and restraint. We have recently addressed incidents of prosecutorial misconduct in several death penalty cases. As a court, we are constitutionally charged not only with appellate review, but also to regulate the discipline of persons admitted to the practice of law. This court considers the sort of prosecutorial misconduct to be grounds for appropriate disciplinary proceedings. It ill becomes those who represent the state in the application of its lawful penalties to themselves ignore the precepts of the profession and their office. They cite a couple of examples: invocation of religious authority or biblical reference, invocation of a higher authority than the law, injecting the jurors our own fear or emotion, admonishing jurors that they would be cooperating with evil and would themselves be involved in evil, just like the defendant, by not voting for death. Okay, so basically, we can go down and read all of it, but they're saying things like, when you're doing your closing arguments, you can't be like, God would want you to put this man to death because biblical law states an eye for an eye, and you can't say things like, if you don't give him the death penalty, you yourself are evil. Right. Basically, is right. What
it's saying. You can't cite religious authority or a higher moral appeal, like biblical references, like you just said. The injecting fear or emotion into their decision-making process. It's like, if you do this and put the fear of God in them, then they're going to be swayed your direction, right? And then you can't tell them you have to impose the death penalty as a duty, because that's not how that works. Arguing that a life sentence would be a miscarriage of justice, and or making the jury feel like it's going to be a sign of weakness if you don't impose a life sentence or impose a death sentence. And then you have down there, you have the golden rule. Basically, the long and the short of it is, it's an argument that asks all the jurors to imagine the victim's suffering. And I find that a little appalling that they even have that in there. But of course, it has been ruled in the past to be a little argumentative or to be grounds for misconduct. But how can you be a juror and not imagine the victim's suffering? I find that hard to believe. But misstating the law, if you say that saying that more aggravating factors automatically mean a death sentence, they can't say that, as in the state cannot say that. Arguing that voting for life imprisonment would make the jurors complicit in evil, like you said. Oh, you're going to hell. You either convict him or you're going to hell, and you're going to be there too, right next to him, or trying to just scare them. If you use a victim impact statement improperly, like to compare the victim's choices to the defendant's choices, then that's misconduct. I can see how that makes sense. Portraying defense mitigation arguments as excuses. I'm not even going to expound on that, but appealing to community deterrence or arguing that the jury must send a message. I don't, some of these are just kind of like Cara was saying, it seems a little bit like a delay tactic to me.
Yeah.
Suggesting that the defendant is in future danger as a jurisdiction for the death penalty. And what was the last one? I think there's two more. Oh, denigrating the defense's expert witnesses or mitigation evidence. and commenting on the defendant's silence or legal rights. You can't say, hey, Stefan, you didn't want to talk to us in the interview, so you're guilty. I mean, you
Right.
just can't do that. You have to, I mean, obviously that's part of that. And then they cited all the legal precedents behind it. So they're asking the court to issue a ruling directing the state to refrain from improper arguments during closing statements in the penalty phase. It's meant to make sure that he has a fair trial so he doesn't get accused of emotional manipulation or legally incorrect statements that would unfairly influence the jury. Does that make sense?
Yeah. Yeah, and they just cite a bunch of things. Basically, like you said, that saying that, you know, just asking them not to, in their closing arguments, say certain things that could be like, you can't throw the book at them. Like basically what we just talked about. Everything you just talked about. This next one, I think I had two of the same one, but I'm going to find this next one real quick. And this is going to be probably the most important one. The next one that I have. Hio, you might have one that I don't because I printed out two. I'm going to read this whole thing to you because it's important. Yeah. This
You
is
just
it.
tell me which one we're going to next, and I'll just pull it up as we go. It's no big deal. Pull it up on my side so I have it.
The 17-page document. Motion to declare unconstitutional facially or facility as applied victim vulnerable due to age, disability, or familial or custodial authority. This is the most important one. Hey, Love to Hunt. Sarah, thank you so much for gifting 5 Speculation Station memberships. That was so sweet of you. Thank you so much. I'll come pick y'all up on the crazy train. It looks like Song Bits, JoJo, Faux Show. I love it. Renee and Kristen were gifted. I think I missed one. Gigi was gifted. Thank you, guys. Thank you, everybody. And please tell her thank you if you get a chance. Okay. I think this is the most important one from what from Hio's reaction when she was telling me about it. And what I've been able to look over. And I'm glad you're up here to help break this one down. So first, let's Google pull what this is saying, basically. I'm going to go ahead and share this tab. It's going to take me a minute to type this all in. I can't speak while I'm typing it because it'll make me mess up. Due to age, disability, or...
Hi, Andrea. Nice to see you too.
Sorry about that. It was a lot to type. I might have typed in. So it's telling me differences. We'll see. Says neither term has. Okay. Hold on. Let me go back. Let me erase all this and we will see what it says. I put too much. Facial versus when a party challenges a statute's constitutionality, the part may argue that the law is unconstitutional when applied to a specific set of facts, or it may argue that the law was unconstitutional on its face, that is, in all of its possible applications. What does unconstitutional on its face mean? In U.S. constitutional law, a facial challenge is a challenge to a statute in which the plaintiff alleges that legislation is always unconstitutional and therefore void. So they're going to say that this law is and always has been unconstitutional, so therefore it is null and void, is what I'm gathering from the definition. Now we're going to see what the document says.
Okay, so before we do that, just a little clarification so we're not all like, this is a motion to declare unconstitutional. The defense is arguing that the specific part of the law should be ruled unconstitutional, either on its face, meaning it's always unconstitutional in every case, or as applied, meaning it's unconstitutional in this specific case. Okay, that's what they're arguing. That's what they're breaking down. 921.141, that's the statute that lists the aggravating factors for imposing the death penalty. And then the reason that they want to challenge it is because they want to make sure that it doesn't violate constitutional rights, the due process, cruel and unusual punishment under the 8th Amendment. Is it too vague or is it overboard? Is it being unfairly used in his case? So they're trying to get the court to strike down the aggravating factor so that it cannot be used against Stephan in seeking the death penalty. So if it's successful, that means they could take away the severity of the sentencing options available to the prosecution. Does that make sense?
Yes, I think so.
Okay.
I think everybody, yeah, I can understand. I hope everybody else can.
I'm sure they do. They're smart people in here.
Yeah.
They're just they want to try to reduce what it is that they're allowed to charge him, that they're going to be able to impose as how severe they can impose a sentence. And if they can get some of this stuff struck down and change some of the aggravating factors that go along with it, then is the death penalty still on the table? So are we looking at life in prison without parole, life in prison with parole? You know what I'm saying? So it's what they're trying to do is try to get some of the statutes declared unconstitutional, either like all across the board. That's why they're saying facially on its face, or is it unconstitutional just in this case as it concerns Stephan Stearns?
Okay, I'm going to read this document. Are you kidding? The next document states that they're going to proffer any and all victim impact evidence. I want to throw that out the window. Okay, let me read this to y'all. It says, comes now the defendant Stephan Michael Stearns by and through his undersigned attorney and requests this honorable court to enter an order declaring Florida statutes unconstitutional and to preclude its application in this case, statutes and or the jury instruction unconstitutional and precluding their application in this cause as grounds would state as follows. Florida sets out the aggravating circumstances that may be considered in determining whether or not to impose the death penalty in a first-degree murder case. It provides, in pertinent part, aggravating circumstances. Aggravating circumstances shall be limited to the following. M. The victim of the capital felony was particularly vulnerable due to an advanced age or disability or because the defendant stood in a position of familial or custodial authority over the victim. And as we know, Stephan Stearns was a familial or custodial authority over the victim. This aggravating circumstance, and it cites a statute, will be unconstitutionally applied. Scroll down so y'all can see what I'm reading. In a manner inconsistent with its legislative purpose. It is unconstitutionally vague and overboard and is not capable of a constitutionally adequate narrowing construction, and as such will be applied in an arbitrary and inconsistent manner. I mean, this is irritating to me because he was a familial or custodial authority over Madeline, and he did what he did. So put him to death, in my opinion. Continuing on, number 2, because this is unconstitutional, circumstance will be used as bias for imposing death sentences in the state because its use makes proportionally review arbitrary, and because its bare terms are all that are required to read to sentencing juries, there being no separate and corresponding jury instruction in that in any way narrows or explains its terms, it as a whole is unconstitutional. Number 3.
So do you get that one right? So the violation of the U.S. and Florida Constitution. They're citing Fifth Amendment due process, Sixth Amendment fair trial, Eighth Amendment protection against cruel and unusual punishment, 14th Amendment equal protection clause, and the Florida Constitution, all the articles, like sections like blah, 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 blah. Like, really? So that it fails to adequately narrow the class of defendants eligible for the death penalty. That's what they're saying, making it unconstitutional under the Supreme Court ruling. So they're taking a Supreme Court ruling and trying to say this is unconstitutional. It violates multiple constitutional protections, 1, 2, 3, 4, and the Florida Constitution. Okay, a little reaching, but yes.
Yeah, that's yeah. And it's irritating, but I mean, you know, they're going to defend their client to the best of their ability. I suppose you could argue that. I hope that it gets denied. So she read number 3, talking about it violates the 4th, 6th, 8th, and 14th Amendments in the Constitution. So I'm on number 4. This is a capital case in which the prosecution is asking the court to impose the death penalty. Accordingly, heightened standards for due process apply. It cites statutes, heightened standard of review. In reviewing death sentences, this court has demanded even greater certainty than the jury's conclusions, retested on proper grounds. Reliability and the fact-finding aspect of sentencing has been a cornerstone of the Supreme Court's death penalty decisions. Hey, Rose Thorne. Some principles apply to guilt determination. Where defendant's life is at stake, the court has been particularly sensitive to ensure that every safeguard is observed. Okay, I don't know what that all means. Number
Sorry,
5.
I was lost in the sauce. What
You're good.
Okay, go ahead.
A death penalty statute is unconstitutional if the standards that are so vague that they would fail adequately to channel the sentencing decision patterns of juries. A capital sentencing scheme must narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. So are they saying that it's unconstitutional because it's a more severe sentence than others who are found guilty of murder but sentenced to life without parole? I think that's what it's saying. Florida statute, we're at number 6 right now. Florida statute sets out the rule for construing provisions of the Florida Criminal Code. The provisions of this code and offenses defined by other statutes shall be strictly construed when the language is susceptible of differing constructions. It shall be construed most favorably to the accused. I mean, basically, they're trying to get him life without parole.
Be right back.
Okay. This principle of strict construction is not merely a maximum of statutory interpretation. It is rooted. Oh my goodness. Okay, it's rooted. Hold on, I lost my spot. In fundamental principles of due process, which mandate that no individual be forced to speculate at peril of indictment whether his conduct is prohibited, thus to ensure that a legislator speaks with special clarity when marking the boundaries of criminal conduct. Courts must decline to impose punishment for actions that are not plainly and unmistakably prescribed. The principle of strict construction of penal laws applies not only to interpretations of the substantive ambit of criminal prohibitions, but also to the penalties they impose. It also applies to Florida capital proceedings. Again, I'm wondering, like, what is it that they're talking about is so vague? Where at this part, the terms of the circumstance are so vague and ambiguous that they fail to channel or guide the senator's discretion in order to minimize arbitrary and capricious action in the violation of the Florida and United States constitutions. The 8th Amendment requires that aggravating circumstances must be construed to permit the senator to make principled distinction between those who deserve the death penalty and those who do not. I mean, he deserves the death penalty. I don't know how we don't get that. Great care is needed in both drafting and construing aggravating circumstances. So, I mean, basically, they're just arguing aggravating circumstance. This tells us, number 10 tells us the specific aggravating factor at issue is in Maynard and found unconstitutionally vague in the way it was explained to a jury. The jury is the senator in Oklahoma was Oklahoma's version of heinous, atrocious, or cruel. At the time, Florida's version of this aggravating factor and jury instruction were virtually identical with Oklahoma. Okay, so they're saying that somebody got off on being sentenced to death because for a crime that was heinous, atrocious, and cruel in Oklahoma, and Florida laws are pretty much the same. So, I mean, I can read through this. I think I'm going to figure out a way to upload this. We'll skim through it, but I think I want to upload this so you guys can read it yourselves. I'm sure you don't want me to sit here and read this to you all day. Number 12 says the aggravating circumstance at issue reads, the victim of the capital felony was particularly vulnerable due to advanced age or disability or because the defendant stood in a position of familial or custodial authority over them. There being no standard jury instruction yet promulgated to guide either the judge or jury in the application of this aggravating circumstance and no judicial decisions interpreting it from which such jury instructions could be drafted. There is no guidance for the senator except the vague and ambiguous language of the statute itself. I'm going to read 13 real quick. Thus, while it appears relatively clear that the gravamen of this aggravating circumstance is that the victim was particularly vulnerable, it is in no way clear how a judge or jury is to be guided in determining the presence or absence of such factor. Even the word particularly modifying vulnerable is open to varying interpretations and value judgment. Okay, so they're saying that basically he stood in a position of familial or custodial authority over them. And they're using terms like particularly vulnerable. Well, what is particularly vulnerable as opposed to just vulnerable or not vulnerable at all? It's basically semantics.
Well, they're arguing that vulnerability aggravating factor in Florida's death penalty statute is too broad, too vague, and inconsistently applied. So it makes it unconstitutional under both the U.S. and Florida Constitution is what they're trying to argue. And the defense is saying that its application, it would lead to arbitrarily imposing death sentences and violations of due process and equal protection rights. So that's what they're saying. All they want to do is declare 921.14 unconstitutional and prevent the use of it in Stephen Stern's case. That's what the relief that they're asking for is. And that excludes the aggravating factor from jury instruction and sentencing considerations. So that's what that means.
Yeah, they continue to talk about the term disability is equally vague, despite the fact that cold calculated and premeditated. They talk about the cold calculated and premeditated. So they're
saying the statute is too vague. They're saying the overall statute is too vague and it's overbroad. Yeah.
Right.
So because it's going to violate this due process. It's going to violate his 8th Amendment right, his 5th and his 14th. It's going to violate his equal protection, which is the 14th. And then it's also going to violate Florida itself. So it's just overall, it's just too broad. We want to throw it out.
Okay. All right. Next. Let me see if I can pull this one up next. What is this? Oh, this is the 3-page document. Yeah, this is the next one. So this one is motion in limine to require state to proffer any and all victim impact evidence. What does that mean?
Catch up.
Okay, I'm going to read this one to y'all because we looked at motion and limine just a second ago.
Show me the top of it, darling, please. I'm so sorry.
Oh, no, you're good. It's the
Sorry.
one that's 3 pages. I don't know if that helps. Comes now the defendant stepping stones by and through the undersigned attorney pursuant to those sections and statutes of criminal procedure and moves and limine to require the state to proffer out of the presence of the jury any and all victim impact evidence as grounds therefore would show as follows. 1. Victim impact evidence, particularly in a death penalty trial, is normally of an extremely emotional nature. Jesus Christ.
So they
He
filed the
raped and
motion in
murdered a
limine.
13-year-old child. What do you mean? It's, oh my God. I need to.
So they're worried about a couple of things. And this is just overall, like, this is normal court stuff. Like, this is what they do to try to keep these people from getting
Right. But
sentenced, right?
extremely emotional nature. What, are you fucking serious right now? What about
Well,
her extremely emotional nature? Because of what was being, I'm just.
They just want to have all the victim impact, evidence outside the presence of the jury before it's presented in court, because they worry about jury bias. They worry about, they're talking about the Florida statute that's vague and ambiguous. They're talking about that still. The victim impact statements are not considered aggravating factors in sentencing. So they're worried about the emotional impact of the witness testimonies, and the defense, basically their stance again. They want to object to victim impact evidence in its entirety. That's what this one is for.
Yeah.
If the court allows the victim impact evidence, then the prosecution has to present it. They wanted to present it outside of the jury's presence so that it doesn't sway the jury in what they do.
Well, usually victim impact statements are read after that, right?
That's what I'm saying. Some of this is just regular court stuff. They just want to make sure the impact witness can testify without, influencing the jury. That's pretty normal. They just want to prevent prejudicial influence, and that's pretty normal.
It's really pissing me off though, because
it's not nice. Yeah, but that goes back to, we don't want to intimidate the jury, put the fear of God in them, and tell them, if you don't see or feel how Madeline felt, then you're gonna go to hell. You know what I mean? That's kind of the premise on some of that. It's just it's pretty normal.
I'll read this one to you since it's only 3 pages. Okay. I was at 1, and I'm going to try to keep my composure. I sincerely apologize for cussing. I do. I try not to do that, but.
Well, we're grown.
I understand that they're doing their job, but it's not acceptable to me. But I'm not.
So hard to see. So hard to see is so right. I think about that often. If I were a defense attorney, would I be able to handle it, knowing that my client was guilty? Could I handle that? Or would I just have to step away? There's no way. I just don't know. I don't know that I could do that. Could you do that, allegedly? Could you be a defense attorney for somebody that you've seen the pictures? You know what I mean? You've heard what the pictures include. How could you defend that?
I don't know. No. Not knowing that he's guilty. I would try to get him less of a sentence, I guess, if I had to do that, but.
Right, Bellas? You should hear us in our cussing. Girl, you've heard me behind the scenes. I'm a train wreck.
Yeah. All right, I'll continue to read this. Yeah, stepping away could ruin your future career path. And I understand that. It's just like, I cannot. Real quick, Sarah said, just remember, you'd want a badass defense attorney if you ever got in trouble or was accused. It takes a special person to do their necessary job. I agree, but.
Kohberger is much worse, Anders. Much worse. I guess. You can't. I really wouldn't want to quantify the difference. Yeah, 4. Not if you're saying 4 versus 1. The crime scene itself was very, it was heavy. It's not that it's any less heavy because it's a child.
Well, yeah,
they're both equally awful.
In their own ways. Right. I don't know. It's harder for I've been digging into the Naziah Harris case today, and I found a bunch of information. So maybe
Janet,
that's
see you. I can see you. I don't know what's not posted.
Sometimes YouTube will kick your comments, and I apologize for that.
YouTube. Mostly, I think we get into the emotional side of reviewing interviews and talking about the personal side of it, and our feelings are involved, and lawyers see it from a different perspective, or they're trained to see it from a different perspective. Obviously, try to take your feelings out of it. Okay, we've got this guy. This is what he's accused of. What can we use in lieu of just letting this guy go straight to prison and just lock him up without due process? What can we do? So it is their job to look at everything and say, okay, well, this, we're not saying that and now from what I know, he hasn't said he did do it, so he's saying he's innocent. It's our job to protect him as if he's innocent and try to fight that, right? That's their job. It's gross to us, but it is their job.
Yeah. All right, I'm going to read this real quick. It says the victim impact evidence, particularly in a death penalty trial, is normally of an extremely emotional nature and has a high probability of unduly, unfairly, and unconstitutional inflaming the jury, thereby making it impossible for a defendant to get a fair sentencing phase of his trial free and bias of prejudice. Well, oh, you little thing, you. Number 2, the definition of victim impact evidence in section is vague and ambiguous and difficult to interpret. In addition, victim impact is not considered an aggravating factor. Number 3, victim impact witnesses, particularly in a death penalty trial, can be extremely emotional and have a great difficulty controlling their emotions while testifying. Number 4, the defendant, by filing this motion, maintains any and all objections to the use of victim impact evidence in its entirety. Wherefore, if the court allows victim impact evidence, the defendant respectfully requests that the court enter an order requiring the state to proffer out of the presence of the jury any and all victim impact evidence, so the court can determine not only whether the evidence is appropriate under the statute authorizing it, but that the witnesses themselves are emotionally capable of maintaining appropriate decorum before the jury, so as to avoid unfairly and unconstitutionally inflaming the jury and causing prejudice to the defendant. And that was it. They just signed it after that.
Don't throw your computer. It's okay.
I threw the paper.
Did you really? I heard you.
Sure,
I heard
did.
something go across the room.
He'll eat it later. He likes to chew my papers.
He could chew that one up.
Okay, this is the one that's coming up next. It's still loading. This is the. Is this the last one? No.
No, this is not the last one. There should be.
Okay. This is the motion to declare sections and or Florida statutes and or the standard instruction unconstitutional and facially and as applied. So what is your breakdown of this one?
Let me see which one we're on.
Hold on.
Go to the top so I can see the title, if you don't mind. I'm so sorry.
No, you're good.
Did we already do this one?
I don't think so. No, it says number 1, the
same statute. So.
With a capital homicide in which the state is seeking the death penalty among statutory aggravating factors, which the jury may consider at penalty phase if supported by the evidence and proven beyond a reasonable doubt, or whether.
Is this the death penalty constitution one? No. Hold
on. Okay, I'll keep reading it. A.
Okay, go ahead.
Let me scroll down so they can see. A, the capital felony was committed by a person previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation. The defendant was previously convicted of another capital felony or a felony involving the use or threat of violence to the person. And emphasis is added on that. That's the one in black here. So that's the one they want us to pay attention to. The defendant was previously convicted of another capital felony or of a felony involving the use or threat of violence to the person. So what does that mean? Like, is he saying, I mean, if he's convicted of the CSAM stuff in February, then yeah, he will be convicted of another capital felony when this goes to trial for the homicide. But is there a possibility he was using threat of violence to Madeline before he killed her?
I mean, he could have been. I suppose he could have been.
It says, C, the defendant knowingly created a great risk of death to many persons, which is not relevant. The capital felony was committed while the defendant was engaged or was an accomplice in the commission of or attempting to commit any robbery, sexual battery, aggravated child abuse, abuse of an elderly person or disabled adult resulting in great bodily harm, permanent disability or permanent disfigurement, arson, burglary, kidnapping, aircraft piracy, or unlawful throwing, placing, or discharging of a destructive device or bomb.
Okay, so go ahead. You're good.
Oh, you're good.
It's seeking to prevent him from being able to be eligible for the death penalty. That's all that they're doing. The defense is urging the court to declare that felony murder aggravator unconstitutional. It's arguing that it just doesn't align with modern standards. It says modern standards.
Okay.
So it has a bunch of precedents that they cite. There's 1, 2, 3, 4. All of them are from 1988, 1983, 1978, 2005. Is what they're saying is everything that they're relating it to is old, and it doesn't really jive with the way things are nowadays. Which, okay, so rewrite the law. You know what I mean? It's like nothing we could do about that. But basically, they're just saying that they're challenging that the death penalty statute, that 921.141 that we were talking about, it's they're saying that they're relying on it as an aggravating factor under Florida law, but it's too vague and it's more in line with different felonies like robbery, burglary, kidnapping instead of. And then that it's also violating the constitutional rights, 5th, 8th, 14th. So this is kind of linking back into the other. They just want him to throw out the idea that he could be tried for felony murder. It's just okay. Or they want him to throw out the eligibility for the death penalty. They're trying to get whatever it is that they're trying to try him for. They want it lowered. They'd want him to do either life in prison without parole, life in prison with parole, but they were going to try to take the death penalty off the table. That's basically where this is all going right now.
Okay. I do want to reiterate what I see out of this. I'll probably put a video out later just reading all of these to y'all, but I know y'all don't want to hear me do that here. That's for the people that like that. Number 3 says the state will attempt to raise prior violent felony aggravator as an aggravating factor during the penalty phase proceeding. So we know that they're going to do the prior violent felony when he gets convicted of the CSAM. I think that's about all we need from that one.
So does CSAM quantify, does it go, the death penalty is supposed to be reserved for the worst of the worst, okay?
Mm-hmm.
So are you saying that they're going to try to use the CSAM case if they get a conviction to use that as like he's the worst of the worst and try to make it expanded into eligibility for the death penalty is what you're saying?
Yes. They're gonna say that, basically he's the worst of the worst and he's been convicted of this felony. So we need to give him the death penalty on this homicide because he's already got a prior violent felony. And the production of the CSAM and all of that would be a prior violent felony, the videos and all that.
So it won't qualify him alone for the death penalty under Florida law. I don't, it's not going to. They're not listed as qualifying aggravators. It's just not.
Let's see.
If convicted of the CSAM charges, Stearns could face multiple life sentences without parole, especially if there are numerous courts. It says if combined with a capital murder conviction, The CSAM charges could increase the likelihood of a jury recommending the death penalty, but only if the murder conviction itself qualifies, not on top of. That's the U.S. Supreme Court. It limited. I mean, there's limited things on that. So even for child grapes, the court has held the death penalty as unconstitutional. I don't know. She didn't die of that. She was asphyxiated, correct?
Yeah. Oh, Lordy Jesus. We looked this up, and I thought it did. That's why I'm pulling this up.
Well, it's not a standalone reason for execution, okay? That make
No.
sense what I'm saying? It's not
Yeah,
a
but
standalone.
they're gonna say they're gonna convict him of this violent felony, and that the CSAM he won't get the death penalty for, but they're gonna basically say that he is a formerly convicted violent felon, and therefore, try to give him the death penalty using the fact that he's committed multiple felonies, or this is his second felony, from what I understand.
If the prosecution tries to argue that CSAM possession was part of a larger pattern of abuse,
well, they can prove that
led to her death, then it could possibly maybe be used as an aggravating factor, but they're not going to use it as standalone for execution. They're just not going to. But they might get it worked in there, but they're trying to set it up now to not include certain things.
Well,
so I think it's a tactic. It's a tactic to get the death penalty off the table. That's their whole reason for doing this.
Yeah, let's pull up this last document we have, because it reiterates more on that specifically from what I just saw when I was flipping through it. So we will get some more information on that part of it. Hold on, I'll scroll it up.
You're good. I just want to see what it says. So I know I'm pulling up the right one.
There. Okay.
Is this the
So
defense
this
motion?
is the motion to declare Florida statutes and or corresponding jury instructions unconstitutional as far as felony murder.
All right, hold on. Let me pull that one up. Does anybody else want a sandwich? I was shaking. I drank so much coffee. I was shaking like a leaf on a tree.
Do we know that, passenger, that is considered torture?
If it's not, it should be. But yeah.
No doubt.
let's
I'd have to
see.
look up Florida statutes. But I mean, I would need the specific, it depends on what, considering the fact that it references him having pictures of, and let me put a trigger warning up, heavy trigger warning, but of children involved in bestiality situations. I think it would depend on what Madeline is doing in these pictures and videos to, I don't know what she was doing. Therefore, I don't know if it's considered torturous. What did you ask Google, passenger? She said, hold on just a minute.
Hold, please.
Oh, bad girl. Thank you. Bad girl says, I'm proud of you both and keep fighting the good fight. Thank you for all your support. Thank you for all your support. That was so very sweet of you. Thank you so much. Thank you. That was so very sweet of you. My goodness. Thank you so much, bad girl. That was so sweet. Thank you. She says sexual abuse of a child is torture as it went on for years. Okay. Rosie, Marley Mom, thank you for being here. Let's see real quick what we can find. When does CSAM...
I'm following you. I'm following you now. In Florida, abuse of a child of that nature can legally be considered torture depending on the circumstances, the duration, the severity, and the intent of the abuse. So you are right on point. Right on point.
Okay. Do you have that pulled up that you can share?
I mean, I can pull up a capital sexual battery statute if you want to pull up a statute.
Okay.
Torture is defined in federal and international law. It says, although Florida law does not have a specific standalone, just like we said, it doesn't have a standalone criminal charge of torture. Courts interpret it as prolonged abuse of a child because of like she was saying, or like me was saying, that it was based on the amount of time that they were doing it. So under their code, human rights laws, torture is defined as severe pain and suffering, physical or mental, intentionally inflicted for punishment, coercion, or sadistic purposes. This standard could apply in extreme child abuse cases of a sexual nature. So yes, it can be an aggravating factor, and it can be considered torture.
Okay. And
It's a
then
good call. Good call.
Yeah, thank you, Passenger, for that. I saw where it referenced sadomasochistic, and I noticed that on the documents we have, there was some sadomasochistic images he had that were not of Madeline. I don't know what he had Madeline doing. Like I said, I don't want to know, because I would drive to Florida and do something in the courtroom and be in jail myself. So, but
if the case it's not a standalone. Torture is not a standalone. So if it qualifies for the death penalty, then the law allows the prosecutors to argue torture as an aggravating factor. So yeah, right on.
Okay, so this is the last document I have. And like I said, Hio, our lovely, is breaking them down for us. I'm going to read the first part of this. We might read this whole one. I don't know, because it does appear to be some important things on this page. And then I'll make a video and put it out later, just reading all of these for those, because I know some people like for me to read all the documents. So it states it's a motion to declare sections under Florida statutes and or corresponding jury instructions unconstitutional as it pertains to felony murder. The defendant, Stephen Michael Stearnsbine, through his undersigned attorney, moves this court for an order declaring Florida statute unconstitutional based on violations of the 5th, 8th, 14th Amendments in the United States Constitution and Article 1 of the Florida Constitution based on the following. Number 1, Mr. Stearns is charged with committing first-degree murder. The state has filed notice of its intention to seek the death penalty if there is a conviction on the capital charge. In the state's notice, it has announced its intention to rely upon the aggravating factor contained in statute, and it says D, the capital felony was committed while the defendant was engaged or was an accomplice in the commission of or in attempt to commit or flight after committing or attempting to commit any robbery, sexual battery, aggravated child abuse, abuse of elderly or disabled adult resulting in great bodily harm, permanent disability or permanent disfigurement, arson, burglary, kidnapping, aircraft piracy, or unlawful throwing, placing, or discharging of a destructive device or bomb. It says this. It continues to say this statutory aggravating circumstance is unconstitutional, but my part is that right there, what I read to you again. Specifically, in the state's notice, it has announced its intention to rely upon the aggravating factor contained in the capital felony was committed while the defendant was engaged. Okay, so that means specifically I'm looking at sexual battery, aggravated child abuse, or possibly kidnapping. And he was engaged in, meaning he was in the middle of sexual battery, aggravated child abuse, or kidnapping, or was an accomplice of, sexual battery, aggravated child abuse, or kidnapping in the commission of an attempt to commit flight after child abuse. So what does that mean? Does that mean that he basically something happened while he was not?
What number are you on?
I'm still reading number 1 and then the number D.
Okay.
They're stating that basically the prosecution is relying upon the aggravated factor contained in this definition number D. And the aggravating factor in the definition is the capital felony was committed while defendant was engaged or was an accomplice in the commission of or an attempt to commit or flight after committing or an attempt to commit. And what pertains specifically to this case would be either sexual battery, aggravated child abuse, or kidnapping.
So if we're still on one, honestly, this is the truth of this. Don't get weighed down in the verbiage. They're arguing this is unconstitutional felony murder aggravator. That's all it is. They're still going on the same statute, 921.141. They're trying to say that the defense is arguing that the felony murder is the least culpable form of first-degree murder, but it allows for the death penalty without proving intent to kill. It's like it's saying that what they're doing is violating both the U.S. Constitution for all of the rights that we've already talked about, the 5th, the 8th, the 14th Amendment, and the Florida Constitution. So because it fails to narrow the death penalty eligibility, the law requires the most culpable offenders should be eligible for capital punishment in lieu of the death penalty. So if you're saying that they don't have enough to put him under the jail or fry him in the little fryer, then he just has to be there for his life. That's what they're arguing for. They want to get the death penalty off of the table.
Right, but
that's
okay. Hold on, real quick. Guilty of crime. How can I get those documents? I'm dropping too, sweetheart. I don't know. My mods got these for me. I'm sure they'd be relatively easy to find, but I'm really not sure. And I really appreciate the support. Thank you so much for that. I didn't get these documents. So unfortunately, I couldn't tell you how, because it wasn't me that personally got them. My mods got them to me like 3 minutes before I came live. Okay. Now,
yeah, I understand what you're saying, Watts. I completely agree. There is also the aggravating factor that the victim is under 12. And they were in a position of trust to take care of them. All I'm discussing today, though, and I completely 100% on board with you. The only thing that we're discussing is what came out as what they're trying to build motions on, and what they're trying to say is unconstitutional. So far, this is all they've addressed.
Right, but my issue is that it's saying that the state's notice has announced its intention to rely upon the aggravating factors contained in this. So basically what it's telling us what happened. Something happened.
No, it's telling you that the state is telling them, we plan on relying on this statute. This is what we're relying on to convict this man of felony murder, and we're going to give him the death penalty. And the prosecution is saying, you can't do that. And these are the reasons why. All of these motions are the reason why. You can't do that because it's unconstitutional. And let me tell you why it's unconstitutional. Because you're violating this man's rights. And this is how you're violating his rights. So all of this is just basically him saying that he doesn't want the death penalty on the table. Please figure out how to get the death penalty off. He hasn't pled guilty. He got a lawyer. We don't know his side. We don't know anything about but the only assumption I can make is that he's saying that he's not guilty, that he didn't do this. He didn't say he wasn't. I mean, we're not talking about the CSAM stuff. We're actually just talking about the felony, murder trial.
And this is going to be the plaintiff versus the defendant. So it was submitted by the plaintiff. But my thing is there is clues in this number D that the capital felony was committed while the defendant was engaged in or was an accomplice or in the commission of or an attempt to commit or flight after committing, attempt to commit. And it cites robbery, sexual battery, aggravated child abuse, abuse of the elderly or disabled adult resulting in great bodily harm, permanent disability or permanent disfigurement, arson, burglary, kidnapping, aircraft piracy, or unlawful throwing, placing, or discharging of a destructive device or bomb. What in there are they going to use? Obviously, it's got to be about aggravated child abuse or sexual battery or kidnapping. And obviously he was engaged in, he was an accomplice, which is going to implicate Jen, but considering Jen has not been charged, I would say he wasn't an accomplice. He was possibly in the commission of sexual abuse or sexual battery. He was attempting to commit
okay.
sexual abuse or battery.
Okay,
He
so
has
let's
no-
run that through. Let's run that through. The capital felony, like murder, must have occurred while the defendant was engaged in, actively committing, an accomplice to, or helping someone else, fleeing after committing or attempting to commit. That's where capital felony is.
Right.
Okay. You have underlying. Okay. You understand the difference, right? So you have a capital felony. These are the ones that are saying this is what he's going to get the death penalty for. But you cannot have them. They're not standalones. You have to have underlying crimes that trigger the aggravating factor. The robbery, sexual battery, aggravated child abuse, abusive, all of these other things that you're mentioning. If any of those crimes were happening at the time of the murder or led up to it, then the state can argue that the defendant qualifies for the death penalty. They're trying to look for excuses and ways to get out of it. The aggravator applies even if the defendant didn't personally take her life, which we're assuming that he did. He's saying he didn't, but he's involved in the crime, and so that would make him eligible also. So if someone robs a store, during the robbery, your accomplice shoots and kills the cashier.
Right.
The felony murder rule would make both of them eligible for the death penalty, even if the accomplice was the shooter. That's the kind of scenario that they use.
So run it with Stefan.
Well, say that again.
I said run it to me with Stefan and what we know.
Well, we don't know. See, that's the factors that we're going off of. So we're assuming that he was either engaged in, an accomplice to, attempting to, or fleeing after. Those are the four things that we're basing the capital felony off of.
Right.
And do they have the evidence to prove that? Do they have the evidence to prove that he was engaged in actively committing, accomplished to committing, attempting to commit, or fleeing after committing? The answer is probably yes.
Right.
But the prosecutor, they don't have, the defense, has the same evidence that we have, right? The same things that are out there in the public, or the same things they can FOIA. They have that discovery plus 400. Are they going to try to say they don't? Maybe. You understand where I'm coming from? It's the idea is that the serious crimes that trigger this are robbery, battery, aggravated child abuse, arson, all that kind of stuff. But you don't have to be the person that did it. If you were part of the crime, you could still get the death penalty. Even if killing was an accident, the law would still apply. They're just trying to get it. They're just trying to get it off of his back. That's all they're trying to do. They're just trying to say it's unlawful. That it's too broad.
Right.
That's what all these motions are about. This particular statute is too broad, and you're going to try to put this man to death based on this particular statute, and that's the one they're fighting right now.
Okay.
They're not concentrating on other aggravating factors right now. They haven't even hit those. The chances that you're going to see motions for this, motions for that, motions for this are huge. But this particular one, what they're fighting right now is this particular one. Can we get the death penalty off the table if we can prove that this statute right here is unconstitutional, or that it's too broad and it violates this man's constitutional rights and due process?
Okay. And that's all.
Because he has tons of aggravating issues. Yeah, this is just the one.
Okay.
I mean, yeah, this is just the one. And this doesn't have anything to do with the CSAM at all. This is only, hey, you guys want to try the death penalty. Let's throw spaghetti at the wall. Maybe this will stick. And the judge will say, yeah, you can't use that. You can't use that. You can't try him under the death penalty using this statute, because this is what he's saying, probably somewhere where the state has said, well, this is what we plan on using. So how do you plan on proving felony murder aggravator? How do you plan on proving it? This is right. This is the statute we're going to use.
Okay. And I'm going to read through this because I see some other things. And if I'm going down a rabbit hole, pull me out and let me know.
You're allowed to go down a rabbit hole. That's what these are for. I mean, we're lay people, right? We're just people looking over a document trying to figure out, well, what the hell does this mean? Yeah. I mean, there are plenty of lawyers out there and plenty of channels that are lawyers that probably know 10 times what I'm saying, but
yeah.
Yeah.
She can break it down really good. That's why she's so awesome. She's my bestie. Passenger said he has more than one aggravating issue. He also has
absolutely normal.
pictures. If they were used online for a monetary gain, then it could also have a federal case for interstate trafficking or CSAM. Yeah, that's a good point.
Oh yeah, and then and Passenger's exactly right. This is so normal for a death penalty case. These motions by the defense are going to just keep on coming and keep on coming. I mean, we're going to have this discussion over and over. Yeah, it'll be like, oh, breaking, but it's really just going to be like, okay, and then we're going to have another one, and then you're going to have another one, and eventually people are going to be like, can we just get on with the freaking case? Like, present what you're going to present and get it over with, because it'll be one thing after another. It's loophole after loophole.
Yeah.
And that is my opinion and speculation only. I am not a lawyer. I am not anything of the sort. I just like to study a lot.
Yeah, she is always forever finding things and studying. She's so awesome.
It's going to be hell annoying. Oh, yeah, hell annoying.
Yeah.
And you're going to want to throw your computer because, honestly, at the end of the day, we have to look at it very basically. There is a child that was just a day over 13 years old who has lost her life, and we can't get it back. And we all have to stand here and we have to scream to the top of the roofs, get this shit over with. This is what I said. I implore you. I implore the family of Stephen Stearns. I implore the family of Jen Soto. Help this man come to terms with what he has done and plead guilty so that all of us and all of his family and all of Madeline's family can just get this over with and just say what you did, get it over with, and hope for the best. And don't make these people study this case for years and years and look at your pictures and what you did to this child. Yeah. She's gone. She's gone. Let her rest in peace. You know, we're going to keep fighting. We're going to keep saying her name. We're going to keep fighting each other for the information. And we're going to keep trying to get it out there no matter what. No matter what. If he would just admit what he did, get it over with, then maybe we would find peace as creators too. But we're not going to stop.
Yeah, I can't.
None of us are going to stop. I know Jay's not going to stop. Plunder's not going to stop. Docket's not going to stop. Grizzly's not going to stop. Allegedly's not going to stop. Just say you know there's 50,000 other strategic eyes. Everybody. It doesn't even matter. We may not all get along here on this platform, but we're all here for the same purpose. Maddie's dead, and that's hard.
Yeah,
to come to terms with. That's why they don't. That's why it's an emotional case. They don't want the jury to see all this stuff. They don't want them to know. They want them to be impartial. Hi, Heather.
Hey, Heather. Also,
108 degrees.
Oh, good Lord. That is hot. I did want to say that video I played, I forgot, I don't know if I said her name, but her name is Period Point Blank, and she is linked in the description box if you guys want to check her out. That sweet video of Madeline she played. It was, oh my goodness. Hey, Pondu. Okay, so I'm going to continue reading this. Number 2 says the statutory aggravating circumstance is unconstitutional as written under the Constitution of Florida and the United States Constitution because the least culpable form of first-degree murder can be used as the sole basis to impose capital punishment in Florida in violation of the prohibition against cruel and unusual punishment. As written and applied, it cites Florida statutes. It violates Article 1, Section 9 and 17 of the Florida Constitution as set forth in the memorandum of law that accompanies this motion. Your Basil update is he's on the bed laying in the sunlight, by the way. Number 3 says evolving standards of decency prohibit execution for felony murder. Really? The felony murder aggravator does not narrow the class of death eligible offenders to the most deserving. I mean, but then how would you justify who's most deserving of the death penalty?
Well, it's based on the law. It's not based on, I mean, if it were up to me and you, he's deserving, right? But They have all these statutes and all these factors that decide whether it's sufficient enough to charge him under the basis of the law itself. And those are all the factors that we just talked about. That's why they're saying you can't charge him with these things under this statute because you would be violating all kinds of, things. You'd just be violating him. And, isn't he violated enough? My client's been through enough. You can just hear them just talking.
Yeah.
Like, how do you hear lawyers talk? My client's been through enough. We're not going to try him for that. We'll try for other things. Let's try to get the death penalty off. The very first thing, try to get death penalty off of him.
Yeah.
That's what they got to do first. So
Lori said, sorry. Lori
No,
said,
you're
with
fine.
Stephen Stearns disposing of Maddie, and if Jen committed homicide on Maddie, that would make him an accomplice. Yes, but if he was an accomplice, I don't think they would have charged him with first-degree premeditated murder. If I had to guess, my question is going to be the Telegram pictures that he sent at like 11:59. If the DNA report says that she was murdered on the 25th and that is accurate, and then we have 11:54 or something like that, he's sending Telegram pictures. What is he sending pictures of? Is that aggravated? Is that the aggravation? Hold on. The felony was committed while the defendant was engaged or was an accomplice in the commission of aggravated child abuse, sexual battery, etc. Like, do they have that evidence, and is that what they're going to go on?
No, because CSAM is a different thing. That's what I'm trying to tell you. They're going to find, I'm not being shitty. I'm just saying they're going to find every loophole they can to get him out of it because that's their job to do. No,
Right.
It does not stand alone. CSAM does not stand alone. But if they can get him convicted of it, maybe they can use it in the death penalty case. As of right now, what the lawyers are planning on is not having that. They're not talking about that. They're not even acknowledging it. Some of the motions you'll see that'll come out might be to exclude everything that happened in this first case, this first trial. We don't know yet. So we're just having to play Russian roulette and like throw the balls on the table and just see where they land. That's all we can do right now. And so that's what they're doing. They're throwing the balls down, seeing if it lands on black.
Yeah.
That's what they're doing. I mean, that's all we can do. We're all on the same page,
Right. Hey Sprout, and hey Rachel, hey Boomer. Yeah, we don't have all the info the lawyers have, said Boomer.
Michelle, you can take the day off if you want. I said you could. You can take the day off, Michelle.
It continues. In Florida, the only matters that may have been considered an aggravating are those set out in the death penalty statute. It cites Zach versus State, emphasis added on aggravating circumstances shall be limited to the following. In Florida, the aggravating factors set forth actually define the crimes for which capital punishment may be imposed. They cite State versus Dixon. The existence of one or more aggravating factors to make a defendant eligible for the death penalty, and they cite Elm versus State. A defendant is not eligible for the death penalty if there are no statutory aggravating factors, because the Florida death penalty statutory scheme expressly requires that sufficient aggravating factors exist before a defendant is eligible for imposition of capital punishment. So, again, they're stating that, well, no statutory aggravating factors exist before the imposition of capital punishment because he hasn't been convicted of the CSAM, I'm guessing.
I mean, they're right now he doesn't have that factor.
Yeah.
I mean, it's not a stacked factor right now. So, yeah, I mean, that makes sense.
Each statutory aggravating factor upon which the imposition of capital punishment rests is a component of whether the defendant is eligible for capital punishment in Florida. A jury could find that one or more statutory factors are not sufficient to justify imposition of capital punishment by the judge. A defendant is entitled to a unanimous jury determination beyond a reasonable doubt as to whether, quote, sufficient aggravating factors exist that legally and factually authorize capital punishment. It is well established that the Eighth Amendment requires that a capital sentencing scheme must genuinely narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. They cite Lowenfield versus Phelps, quoting Zant versus Stevens, where the eligibility for the death penalty depends on finding sufficient aggravating factors. The felony murder circumstance becomes an automatic aggravating factor following a conviction of first-degree murder. and does not serve the constitutionally mandated purpose of genuinely narrowing the class of persons eligible for capital punishment.
I'm sorry, I'm not laughing at you. I'm laughing at that comment.
The CSAM is pretty much a home run for the state. They got his Brody tic-tac on camera. Lord have mercy.
Tara. Brody tic-tac. Yeah, Sprout, right? Magnifying glass. They literally were like trying to get up real close. And has everybody seen that video? That's one of the things they have on Patreon. Trust me, you're not missing much. With the glasses trying to get real close. Like, oh, is that a I would hate to have been the person to be that close to that man's crotch.
Oh God. And she says, if you do anything swirly, you're going to eat the carpet.
Yeah, she does say that. She does say
That's so funny.
No, I won't show you. I won't show you. I promise. Hi, Bree. How are you doing?
Have I told y'all the story about when I first started my lives? How I think it was just me and Jenny Jen in here. Jenny Jen was like, she's my day one person, and I had got the FOIA request back. You know, this information was already out, but I think I was the first one to put it was just coming out, Stefan's interrogation, and we were looking at that stuff, and I was listening to it, but I looked away for a minute, and I looked back up, and there it was, just right there on the screen, and I was like, holy shit, I had to end the live immediately. So I was like, and then I had to fix it and put the pumpkin over it. I was like, I gotta go right now, and ended it.
That's funny.
Yeah.
Oops. Yeah, and I don't know how many people were over it, but I know that All Things Serious was doing a live, and I was over there, and we were talking about something. I can't remember if it was gentle parenting or what the thought process was, or something mental health related. And I knew you weren't around. You were out like doing dinner or something. And he's like, oh, allegedly speculating is in the back. And I was like, oh, well, this bitch, she told me she was cooking. So he pulls it up on live, and it was you know, it was what it was. And he was like, oh God, I gotta stop this live now. And he like had to turn it off and run. He was so embarrassed. It was literally like a dude going at it. And it was, it had your name on the bottom. And I was just like, allegedly, my goodness.
Yeah, I had to come up immediately after and apologize. I was like, I swear to God, that was not me. It was crazy. And he knew it wasn't me, but I don't know who stole my name. And like, oh my God, that was crazy.
Anybody that just kind of saw who was in his live and kind of went from there. Bye, Michelle.
What was I highlighted?
Yeah, they did. They did, Sarah. That's gross.
That was crazy. Hold on. Oh yeah. Glitter is forever. I believe what the state is betting on is when he goes to court for the CSAM and is convicted, that will be his aggravating factor for the death penalty in the next trial. That's what I'm thinking they're doing. I'm wondering if they're trying to get the death penalty thrown out, though, because he hasn't been convicted of the CSAM yet. Is a question I'm having.
I will tell you what I learned today in this hour and 45 minutes that we've been up there. And I have been so happy about that. When one of your subs just have like the most moment that gives me an epiphany, the abuse as torture. I don't think I had thought about it in that direction because we've been talking so much about the different directions of it, but the abuse as torture and where the legal basis stands on whether they can, if they can use the federal law to charge him with a death penalty based on the torture aspect of it. I think that's absolutely the most insight I have had during this whole live today. So I just wanted to say thank you to that sub, because I'm completely and 100% on your side on that. And I think that's eye-opening to me. So I definitely will research that a little more just so I can get a good feel on that. But I do think that is a possibility now that I'm looking at it. I think that's wonderful.
Yeah. I think it's a possibility too. Hey, M Show. Glitter is forever said, I believe even if they didn't split them up, they will get a unanimous death penalty, but I think they split them up so they can almost guarantee a conviction with death penalty. Yeah, I think so too. I think they split them up because, again, they want to use the CSAM as mitigating factors, or basically he's been convicted of a felonious thing or the torture thing. I mean, there's a lot that we don't know that could be pulled up and used in this. Aw, Katia, thank you so much for the support. I really appreciate that. That was so sweet of you. Thank you so much for that super sticker. Thank you. I really appreciate that.
So what you said was very interesting. So usually a prosecutor, because they do try CSAM and murder charges tried together all, I don't want to say all the time because it's not all the time, but they usually can bring them together if multiple charges are tied. Like if there's connected facts or connected events or patterns in a CSAM case that can be combined with a murder case. You know what I mean? So like if she was murdered to silence her or to destroy evidence of the CSAM, like if he was abusing her and feared that she would report the abuse and that led to the murder, then both crimes could be tried at the same time. If they found, obviously they did find the CSAM during the investigation, so that automatically ties it in together. I don't know. They file separate CSAM charges in the same case, but I don't, he was arrested for both of those. I mean, he was arrested for the CSAM, but he was also charged with that like months later. Obviously,
Yeah.
I'm guessing because they had to get all of the stuff together that they needed to in order to make sure they had an airtight case. But I do find it interesting that they're not, I mean, the sexual abuse itself and the I call it organized crime, because if he was on Telegram and he was selling and swapping and doing all of the things that go along with that, a trafficker's killing his victim because he's trying to escape the authorities or anything that's linked to his CSAM operation automatically, So I do find it, hard to believe that they didn't try that together. I don't know.
I think, like I said, I think they're going to use it for that. I'm looking into the Harris case. I do want to deep dive that with y'all. I found some things.
Who's the Harris case? Remind me.
Naziah.
Naziah Harris. Okay.
Yeah.
I'm like Caleb Harris. Naziah Harris. Okay. I couldn't remember if we're talking about somebody.
Yeah, I was deep diving that. I think we're going to stick with just this today, and then tomorrow we'll probably talk about Naziah.
Yeah, so hard to see. It totally did. And I even read a Reddit post where Bree a couple of months ago, like maybe 4 or 5 months ago, from Guilty of Crime, had to go into Reddit and tell people like, yes, it looks like the storage is a whole operation for CSAM, but then she ended up clarifying. I ended up calling and talking to the lady that was there during the investigation, and she was like, yeah, clearly it looks like that, but there was paint cans everywhere, so it had nothing to do with that. The only reason they took it because they wanted to know when we were doing our security checks and what all of these numbers were in there. So
yeah, she called one day on the live and clarified that for us. I've seen a lot of people deep dive in the Naziah Harris case. I've seen a few things that I'm like, I really want to talk to you guys about involving that. All right, I'm going to read this part because it says some things that I found interesting. It says, evolving standards of decency render the felony murder aggravator unconstitutional. I pulled it up where we're reading at. The 8th Amendment prohibition against cruel and unusual punishment includes punishments which are disappropriate for the offender or the crime is determined by evolving standards of decency. Evolving standards of decency mark the progress of a maturing society and is a standard for evaluating governmental practices under the 8th Amendment. Graduated and proportional punishment is a precept of justice, and they cite Weems versus United States. The Supreme Court has held proportionality review under evolving standards of decency should be informed by objective factors, and the clearest and most reliable objective evidence of contemporary values is the legislation enacted by the country's legislators. Another thing just came to mind, and I'll talk to y'all about that in a minute. Of the 27 states that authorize the penalty of death for capital murder, only 10 Oh yeah, okay, we're still on this page. Only 10 authorize for a defendant who unintentionally, accidentally, or negligently causes the death of another person. So, taking the first part of this into consideration, where it says the capital felony was committed while the defendant was engaged in accomplice, commission of, all of that, aggravated child abuse, sexual battery, or kidnapping, and then this right here cites that a defendant who is unintentionally, accidentally, or negligently causes the death of another person. Again, I think they're citing this. Like I said, I mean, like Keo has said several times, they're going to throw everything at the wall, but I feel like these are because, like, okay, I feel like these are important because reading the number D, I mean, obviously he wasn't involved in permanent disfigure, arson, burglary, aircraft piracy, or placing a bomb, right? There's only so many things that we can take out of that relate to this case, and that would be sexual battery, aggravated child abuse, or possibly kidnapping, right? And it says they're citing that specific statute. The capital felony was committed while the defendant was engaged or was an accomplice in the commission of, or an attempt to commit, or flight after committing those things: sexual battery, child abuse, or kidnapping. And then right here it says that basically in
Let me clarify something really quickly, please. Bree, what I said was Bree, from Guilty of Crime 4 months ago, clarified that was not a CSAM out of a storage locker. That is exactly what I said. I agreed with you, ma'am. You're right. I absolutely agree with you. You did not say that it was. I said you clarified misinformation that people were running with on Reddit, and you were able to clarify the opposite. That's what I just said.
Okay. So, and then it says, only 10 authorize it for a defendant who unintentionally, accidentally, or negligently causes the death of another person. So, again, I mean, that would make me think that Stephen was in the middle of committing, attempt to commit, or helping Jen, whatever, commit sexual battery, child abuse, or kidnapping, and a death unintentionally, accidentally, or negligently occurred. And it's stating the national consensus is against the death penalty for a felony murder. And I'm going to read the rest of this page because it kind of finishes out, but that's what I'm gathering from this. What the other part of this I was thinking about is in the state of Florida, there's more strict laws, right? Like Florida, you can get in trouble in Florida for things you can't get in trouble for in other states, or that wouldn't necessarily cause the death penalty. I mean, if you think about it, there's states that don't even recognize the death penalty. They don't have the death penalty in that state. It's only you get sentenced to life without parole. So again, I would think they're going to use a lot of that to say that, well, the Supreme Court says this, and these states don't even have the death penalty, so obviously the death penalty needs to be off the table. I think that's going to have a lot to do with these, but what I'm looking for is like what I just said, the things that stand out to me, what I was just stated and have stated several times. The felony was committed while he was engaged in, was an accomplished, commission of, or an attempt to commit, and the only ones that would apply that I know of would be sexual battery, aggravated child abuse, or kidnapping. And then, like I just read to you, a defendant who unintentionally, accidentally, or negligently causes the death of another person. So that would tell me that he unintentionally, accidentally, or negligently caused the death of Maddie. I'm going to continue reading this. The national consensus is against the death penalty for felony murder. Compare these numbers to the following context in which the state Supreme Court has found national census against state punishments. Atkins versus Virginia, 20 of the 38 death penalty states authorized the death penalty for the mentally disabled. Roper versus Simmons, 20 states had the death penalty for juveniles. Kennedy versus Louisiana, 6 jurisdictions authorized the death penalty for child rapist. Edmund versus Florida, and 8 jurisdictions authorized imprisonment of the death penalty solely for participation in a robbery during which an accomplice committed murder. Okay, but to be fair, if I was going to say that, I mean, obviously he wasn't, like, they're citing, you know, what did it say? People participation in robbery. Like, I don't think he was in participation of a robbery, and they cited that. So I don't know. This last paragraph reads, capital punishment must be reserved for those offenders who commit a narrow category of the most serious crimes and whose extreme culpability makes them the most deserving of execution. An offender who is eligible for the death penalty as a result of committing a felony with no proof of premeditation cannot fit this criteria. And the standard instructions do not meet the constitutional requirement for narrowing the class of persons eligible for the death penalty, and in fact has the opposite effect. In Florida, felony murder circumstance is unconstitutional as explained above. Yeah. So I'm questioning, I mean, it may be because of Madeline's age. It's a possibility. Oh, thank you. She said the analysis on this channel is really good. Hio's amazing. She helps me so much.
She's going to have to come up sometime. I can't wait to meet her. Oh,
Yes.
Bellis. My goodness. Throwing
Thank
everybody
you.
out of the bushes.
Yes, she is. She's pulling everybody out the bushes. Thank you so much for gifting 10 memberships. I will see who got that. It looks like Tynes, Talent is a Beast, Bryn and Annette, Convict Ballerina, Deanna, Spacey Tracy, and Tina was gifted. Oh, Lady Dragon and Drunky the Bear. Oh, that was so cool. I like doing that. Thank you so much for that. That was so very sweet of you. If you were gifted a membership, please tell Abellis thank you. And I will come pick y'all up on the crazy train for Speculation Station. I'm going off the rails on a crazy train. Thank you so much, Abellis.
I don't know who we're hitting underneath, but those workers are going to need lawyers for their concussions.
Yes. People riding my train are going to be tucking and rolling to get off. They're like, hell no. Let's see.
I don't know. I don't. Yeah.
Oh, sorry.
Read that
Go
real
ahead.
quick. No, yeah. No, read that real quick.
Rominator says, I hope they're not misusing the CSAM that Maddie is in. I wonder if that's why Jen is getting away with things, like she made a deal with a crooked cop or detective. I don't think she made a deal with them. I see what you're saying now. I don't think that
This is the same person that had said that they felt like a dishonest investigator was using Maddie's images for personal use, which I disagree with completely. I don't think that any of the investigators are using Maddie's images for personal use. Of course, I'm not there with them, but I tend to hope that our law enforcement is not doing some stupid shit like that. So I just don't want to run on the premise that all cops and detectives are crooked. I just don't want to run on that premise. I want to try to believe as much as I can that the law enforcement and the states and even the prosecutors are all doing their due diligence and trying to keep up with the way that justice needs to be handled. And I don't really want to throw crooked cops or detectives under the bus unless we come up with what we did yesterday, where you end up on a Brady list because you accidentally posted a picture of the crime scene from your personal cell phone, that kind of stuff. But other than that, I don't really want to run with that personally.
Yeah, I don't think that the cops would be using that for personal use. I certainly hope not. Now, like she said, we're not there. We do not know, but I certainly hope they're not. Hey, against all logic, Bear and Marshmallow, laughter is medicine. It's good to see y'all.
I agree, Rosie.
So that was the end of the last document. Like I said, I am going to go soon so I can put out a video reading those documents, but I thought that maybe we could go listen to the jail call again and see what we can figure out from the jail call pertaining to these documents. See if there's anything that maybe we can pick up on now that we know some of the things that we know from this document. Hold on just a minute.
While you're going over that, I'm probably going to jump down because I need to go see my nanny. She needs a hair washing.
Aw.
And we need to have some coffee. So it has been so spectacular to be in the live and in the chat with everybody today. We've had fantastic viewership and fantastic conversation today. So I really appreciate it. It was nice to see Jay. It was nice to see Bree over here. It was nice to see everybody.
Yeah. Yeah, thank you guys for
That's-
coming, and thank you for coming up and helping
Thank
me
you.
decipher these documents and getting them.
You guys have a good rest of your life.
Okay, thank you. I really
Bye, love.
appreciate you. Bye. Annette says, "Hi, thank you very much for the membership. I'm new to your channel." Well, I'm glad you found us. Okay, I do want to reiterate that this is all speculation. I do not know. I was not there. I did not see. I do have the jail call that we're going to listen to and see what we can figure out pertaining to the documents. What kind of avenue they're going. I'm going to start this over. Thank you, Hio, so much.
For English, oprima el 2.
Okay.
The time is 2:01 p.m. If you believe that you are the victim of sexual or physical abuse, press star 9021 after this message. Press 1 to place a call. Press 2 to enroll. Press 4 for the message system. Please enter your PIN number followed by the pound sign. After the tone, please say United States of America.
United States of America.
You have 1.
Yep, the United States of America is going to make sure that you never see the light of day again, sir.
Message. To listen to your messages, please return to the main menu. Press 0 to make a prepaid collect call or speed dial call. Press 1 to make a debit call. Press 8 for calls within the United States, Canada, and the Caribbean. Please enter the area code, prefix, and number. To make an international call, please enter 011, the country code. Your account balance.
That says 555-555 FAFO. If you know what that means, if you know, you know.
Balance is $40.13. The cost of this call will be 21 cents for the first minute and 21 cents for each additional minute, excluding taxes and other applicable fees. The time limit is 15 minutes. Press 0 to continue or hello, you have a call.
I thought these were funny because that boy seemed so angry. And this person's like, well, okay then. I thought that was hilarious to me. I was in a playful mood that night.
Call at no expense to you from
Stephen Stearns.
an inmate at
Osceola County Corrections Department.
To
Hey,
accept
Bartley
this
Bub.
call, press or say 5. To refuse this call will be recorded and subject to monitoring at any time. Thank you for using IC Solutions. You may begin speaking now.
Happened.
Hey,
Where the hell you been?
I've been trying to call. We've had us on lockdown so often. Every time I've asked it, we've been on a code 5 lockdown.
It's F around and find out. That's what it means. F around and find out.
Okay.
Which means I've been unable to call. I've been trying to call all weekend too.
So you've been in lockdown all this time?
Off and on, yes. On the days that I've asked, we've happened to be on lockdown, which means either an incident has happened or they're just so understaffed that they have to lock everyone down. It's probably more to do with understaffing.
Okay. How you been?
Well, you know, had the world's shittiest birthday present, so.
That pissed me off. And I wrote in the video, you asked, what about Maddie's birthday? Like, you had the shittiest birthday. Jen had the shittiest birthday. What about Maddie's birthday? She didn't even get to enjoy her new gifts. Like, what the fuck are you talking about, sir? Excuse my language.
Yeah. And
Thank
then
you.
you didn't call, so I'm assuming because of changes that they prevented you from calling?
No, they were actually moving me around a lot, shuffling back and forth, so I was having to get my phone privileges jockeyed back and forth, which takes a little while. And then, like I said, the days that
Hey, Stoic and Gothic, I apologize for not saying hey to y'all.
I was asking, we happened to be on lockdown on those days. So it's just been inconvenient.
Okay.
Very inconvenient timing, and then we were on lockdown all weekend. I wanted to call on Mom's birthday. I tried to call yesterday. I tried to call Saturday, and there's no go anytime. So, but I've been wanting to call. How have you been?
I'm trying to put this on speaker.
Yeah.
I'm trying to put this on speaker. Okay.
How have you been?
Right, Tony?
Can you hear me?
Good. Can you hear us?
Yes. Is Mom there with you?
Yeah.
Mm-hmm.
Can you hear me?
What's that?
Can you hear me?
Yes, I can hear you. Is Mom with you?
Misty Mo says, as long as you're in the same county jail, regardless of what section, you don't have anything to do with phone privileges. No, you don't, unless he got in trouble. I know he's in, well, you just said it doesn't matter what section you're in. A lot of people speculate that he didn't want to talk to his parents after his parents started speaking out on like hidden true crime and stuff. They think that he was intentionally avoiding them, excuse me. Yeah, F around and find out. Social media is using it like a virus. It has gone wild.
With you?
Hang on a second.
Okay.
All right. Can you hear me?
Yes.
You can hear me?
Yes. Can you hear me?
Yes. Okay. That's on speaker.
Okay. Is Mom?
I found it interesting that the dogs start going off when the phone's on speaker. I'm wondering if they're hearing Stefan and going off.
Yes, Mom's with me now.
Okay. Happy birthday, belated birthday, Mom, and happy belated Mother's Day.
Hi, sweetheart. I was so hoping to hear from you. I'm so glad I'm hearing from you now.
Yeah, I'm sorry I wasn't able to call you all weekend. They had us on lockdown, so no one was able to do anything.
He does have live.
Were you expecting these charges?
No.
The murder charge.
Oh, well, we know you didn't.
Okay, so you got blindsided by that.
Yeah. Obviously, it's not true. I never would have wanted her gone for any reason.
So obviously it's not true. I would have never wanted her gone for any reason. Does that have anything to do with the fact that it was committed as unintentionally, accidentally, or negligently, or does it have anything to do with him being an accomplice in aggravated child abuse, sexual battery, or kidnapping? Is kind of my question. He dropped the deets for us. September 10th, 2025, 9 a.m. is the pretrial. On the 22nd is the jury trial, and I don't know if she dropped the CSAM. I'm looking. No, I think the CSAM is like something's happening February 12th. I think that's the pretrial and jury selection. And I think the actual trial starts possibly on the 26th of February. I'll have to look it up. Yeah. Oh, it was an accident. You can go home now. Shell said, isn't it something Jen cried about her own birthday coming up in that interview and Stephen Stearns felt bad for his own? That speaks volumes. Justice for Maddie, the one that deserved her birthday. Yes. Exactly. It's really sad.
So, premeditated first degree is kind of a dick punch.
Yeah.
No, I was wondering if you had any updates or anything.
So again, the premeditated part would be a dick punch if it was unintentional, accidental, or negligently. Marley, Mom, I'm thinking it will be postponed if the defense has their way. The prosecution has their way, absolutely not. In my opinion.
Nope, we haven't heard a thing. Just, speculation that she's been
hiding
put in an institution and hiding in an institution.
at her lawyer's request.
Yeah.
I mean,
And again, they keep looking into Jen. Is it because they don't want to admit that Stefan did this? Or is it because Jen's actually involved and he was an accomplice in aggravated child abuse, sexual battery, or kidnapping?
are you cooperating with police about her participation in any of this stuff?
There's been no opportunity for me to cooperate with anything. As I understand, the police keep saying that I'm uncooperative, but they haven't asked me anything to cooperate with, so whatever that means.
I can tell you what that means.
So
when you go in and the first thing you say is, I want a lawyer to the police, or, when they start questioning you and you get to the point you don't want to talk about and you say, I want a lawyer, they're going to say you're uncooperative because you did not cooperate with them in questioning, even though it is your constitutional right to ask for a lawyer. I assume between this phone call and now, he's obviously talked to his attorney, and that's why they're filing these things. Or, I'm sure he's told some things to his attorney, but again, I haven't seen charges for Jen, so I don't know. Like, if he could prove Jen was involved, I'm sure he would, to get the death penalty off the table.
Your attorney isn't approaching them and saying, my client would like to speak with you?
No, my attorneys are pretty much saying to keep my mouth shut until the trial starts.
Well, okay.
Okay. I don't know why they were going to wait till the trial, but that's their business, not mine.
They don't want anything to hurt my chances.
Yep, understand. Okay.
Hey, what was Joey's last name?
Beltry?
Yeah, Veltry.
Joey Beltry? Beltry?
Beltry.
Beltry or Beltry?
Feltry with a V. Like victory.
V.
Okay. All right.
So, yeah, it's basically, obviously this confirms that they're artificially inflating everything up as high as they can possibly do it.
And to be fair, they are going to try to get him with everything. They're going to throw basically a bunch of stuff at the wall to see if it sticks. Just like the defense is throwing a bunch of stuff at the wall to see if they can get the death penalty off the table. Until the trial starts, he isn't going to testify, I don't think. Do you? No, I don't think so. Oh, that's so sweet, Rachel. Carr said this picture of Chris Stearns looks like an ad for a laxative commercial. That's to Colin Blow. Thanks to Colin Blow, I can now enjoy my life without feeling stuffed. You are so funny.
Yeah, they are.
Yeah.
So I don't know
what'll stick.
What the plan is there. If they're just trying to scare me into pleading down, or I don't know.
No, they're not.
Okay.
They're just trying to hurt me as much as possible.
Are you able to share the Saturday night before you left for Kissimmee? You were pretty upset about something. Did they have to do anything with Kissimmee in the events that took place the next couple of days?
No.
Okay.
No, I was just stressed out about money and job and everything like that.
Some woman got on a YouTube thing and said that
So he was stressed out about more than that, but obviously he's not going to say anything over the phone.
You weren't even at the party.
I found it interesting that his mom didn't know he wasn't even at the party. Because he's not allowed at the party. So what was he telling his parents as far as the party goes?
Party?
Yeah, her birthday party.
Yeah, I haven't gotten there yet. I went up there Sunday evening and got there after she was done at her party.
Oh, okay.
And we were very happy that I was there. We were very happy that the three of us were together. It was shaping up to be a great week and a great visit. You know, there's no reason for anything to happen that happened.
Is there some explanation of I came up Wednesday morning, met you at the hotel early in the morning, and is there some explanation why you left and went where you went?
I was driving around.
Sir, that's not an explanation.
Okay, understood you were driving around, but they know where you were driving around.
Yeah. Well,
And we know.
okay. I had wanted to grab a few things and get my ducks in a row, kind of prepare myself for whatever was coming, but I couldn't find what I was looking for.
Okay.
And then I ended up just kind of driving around aimlessly.
Okay. I mean, you asked me to come up, and we hardly spent 35 minutes the entire time I was there throughout the entire day. And it's like, I wasn't sure why I was there. And then I was caught off guard by what happened later that afternoon, and obviously haven't seen it since.
Yeah, well, I just felt like I needed an ally there.
Well, I wish you had.
Why did he feel like he needed an ally there? Glitter is forever says, I believe the parents are speculating like us. Wondering what kind of mother would not know. Yeah. I think so too. Pleading down to what? I don't know. Diamond Girl. Yeah, we know he used his parents' Wi-Fi, and they do too, but they're trying to be guarded because they're on the jail call where it's recorded. Jennifer said, why do his parents think Stephen will tell them anything when they themselves have said he's a liar? Good point. I agree. That makes me mad too. Like anyone cares how their birthdays went, shaking my head. What a thing to say. Right.
Come to me and talk to me about some stuff, and maybe we could have helped you out in some way, giving you some advice. But certainly, under the extenuating circumstances, what was later discovered obviously couldn't help you any further than what had already taken place. So the most logical thing would be to have, faced up to it and have a conversation with the appropriate authorities or get an attorney or something.
And basically his dad is like, why didn't you say something? Why didn't you tell me so I could help you? You didn't even say anything. You called me down there and didn't say shit to me. And now this has happened. Obviously upset.
Be that as it may.
Yeah.
Well, we got a copy of your birth certificate for Sheila Marino and for your case. We're trying to get hospital records from the TBI, but Sarasota Memorial says you were never a patient there, so that was ridiculous if you know you were.
Yeah. And were you able to find my social security card?
Yes.
Good. I presume it was probably in that mouse toy box with everything?
I don't know.
No, it wasn't. No, I don't.
Glitter is forever says, but unless she confesses, how would he prove she was involved unless they have evidence they're not telling us about so they can secure his conviction and then use him against her? I think they're going to use her against him and then possibly go after her after that from what people are saying. I don't know. I don't know if they have any evidence with her on it because they state in a July interview with the parents that they went through literally line by line and can determine Stephen worked independently. So that would tell me there are no charges coming for Jen Soto. Yeah, it's possible he didn't want his dad involved any more than he already was. They could form a complete circumstantial case if they have enough, because remember, the circumstantial evidence hold as much water as tangible evidence. Sometimes you can convict on that. Sometimes you can't. Yeah, I don't like the smacking either. Hey, Linda.
I don't recall where it was, but it wasn't there. But
I don't remember if you had confirmed or not. Were you able to find my watch?
No, we weren't.
Yeah.
So
There was no popcorn box.
Little silver mouse.
We already had your social security card, so why did you think we need I already knew your number. Why did you think we need to find the card?
Just in case I was going to need it in the future.
Okay. Well, we have that.
How long I'm going to be here, if or when I'll ever be released, or if you guys are going to be around at that point. But birth certificate, social security card might be things I'll need in that case.
Well, the penalty for the crimes you have been charged with carry a minimum 40-year sentence. So obviously we're going to be gone. Rick will be gone. We'll all be gone. I mean, we're sad about that, obviously, because there won't be anybody here for you when you come out.
Yeah. And I'll be lucky if I have another 40 years left in me either, so.
Yeah.
I mean, I guess everything sticks.
I wish there was a way that.
He said, I think I just picked up on that's if anything sticks. So again, I mean, I just wonder what he thinks he knows or what he thinks he can prove that's going to get him off of this. I was looking at what you're saying. Carolina said, in my opinion, he doesn't care about anyone but himself. He proved that the night Maddie went missing, fake crying in his interview. Yeah. His dad is not holding back, Lori. My guess would be Jen. Yeah. Yeah, Gray Moon. Chris Stearns is like, well, you ain't getting out of there.
You and I can have a conversation. All of us could have a conversation to understand what's taken place, how this came about, how you arrived here, because it would help us better understand the situation, because we're at a loss for understanding how all this came about. I mean, we're just totally baffled.
Well, I didn't start it.
Oh, you didn't start it, but
you didn't start it. What does that mean? A lot of people have talked about victim blaming, but I don't think that's it. Again, I think he's implicating that Jen started it. Now, whether that's true, whether he can prove it, I don't know. But that to me says that he's implicating that Jen started it, or somebody else that Jen was with before him. Hey, Katie, and hey, Robin, good to see you. Yeah, he's sucking on something or eating something. Didn't start what? My assumption would be the CSAM, the abuse.
But you participated in it, which is just as bad as not starting it, but that's for another day. Again, I don't know if
details or anything. I mean, if you'd like to schedule a visit with me or something, maybe we can find some way to talk.
I don't know. I think we're always going to be recorded, so there won't be an opportunity to do that. Now, we have to make arrangements for you to sign off on a.
He's like, you should have done that when you called me down there. A lot of people do think he's victim blaming and Maddie. I don't, but I respect y'all's opinion on that. Diamond Girl said, if they can convict someone of unaliving a person without a body, why can't they find circumstantial evidence to arrest Jen? That's a great question. That's a great question.
A power of attorney so we can do something with this car. Yeah. And I would have to bring a document over. They won't even let me see you. I would just hand it to the classification officer. He would bring it in, you sign it, they would notarize it, give it back to me, and I would leave.
Okay. I think I just got the 1 minute warning.
Okay.
So yeah, give them whatever you need, and I'll sign whatever I need to sign. In the meantime, I'll try to call back in the next couple of days and we'll talk some more. If you wouldn't mind putting a little more money in my commissary as well.
All right, I can't do much stuff because we are really, when I say dead ass broke, I mean dead ass broke, but I'll do what I can.
Okay, I appreciate it.
That could change, but right now, for the next 30 days, we are definitely in lockdown.
Yeah, I understand.
Okay, all right.
Maybe
I'll try to get over there within the week to get the POA taken care of.
Okay, there's a 15-minute cooldown before I can call back. I'll see if I can call back again. If not, I'll try to call back in the next couple of days.
Okay, thank you. All right.
Okay. All right, I love you. Bye.
Bye.
So I don't know. I find it interesting, especially knowing what those documents what we read in those documents. I find a lot of that interesting. I do want to go back and play this video from Period Point Blank to remind us all while we're here, in case he was trying to say, I mean, for so many reasons, but specifically referencing this live right now, talking about, Madeline coming on to him. I just can't. I can't. If he does think that he's sick, and we know he's sick, but more sick than I ever thought. I think we will talk about Naziah tomorrow. Carolina said he's probably throwing us all for a loop and he's just talking crap. Didn't start what? Remember, he knows his phone call is being recorded, right? So he could be implicating Jen in that because the phone call is recorded. Aside from the CSAM of Madeline Soto and those crimes, there is 35,000 images of child stuff, and he can spend life just for that. I doubt Jen Soto had anything to do with that, but who knows? Yeah. His father, on the other hand, is telling him the truth. No one will be alive if he ever gets out, in my opinion. Yeah. I don't think he will get out. I think they found the hard drive. I think there was documents from April saying that the dad found the hard drive and turned it in. I could be wrong, though, if I remember correctly. All right, y'all, get ready to cry again. This is Period Point Blank. The video's linked in the description box. I'm going to play it one more time. Maybe.
The next page is includes.
Not today. Hold on just a minute. Yeah, it's really sad. I love that video of her. I'll leave it regular size. Or get it big before it starts. Let me try that.
Never know, dear, how much I love you. Please don't take my sunshine away.
I know.
She is just absolutely precious. Lord have mercy, it's so hard to watch. Diamond Girl said the car should wait. When he is convicted, they can sell the car without Stephen Stern's signing. They sell cars as abandoned, yeah. Yeah, so that's going to be it for me today. I'm probably going to try to jump on and get these documents out for those of you who want me to read through them and want to see them. I'm going to try to work on that, probably get it recorded. I'm thinking I'll have it out tomorrow, hopefully. It depends on how long it takes me to edit them. So be on the lookout between tonight and hopefully tomorrow for that to be out. She did have such a huge personality. She was so precious. It's so hard to watch that video. I had never seen that video of Madeline doing that. Girl, I cried. The first time I saw it, I cried too. And I cried a minute ago. I'm trying not to cry now. Oh my goodness. All right, y'all. I'm going to go for the day. Thank you so much for the support. Thank you for being here. I could talk to myself till the cows come home and I would be just talking to myself. So thank you all for being here. Thank you for your support. It means so much to me. I cannot thank you guys enough for being here with me, being here with us, going through this case, even the documents, which not everybody likes, and just trying to see what we can figure out. I appreciate each and every one of you so much. And I will see y'all tomorrow. I hope that you have a good Friday, the best that you can, especially after seeing that video. Be safe out there and enjoy your Friday night, and I will see you Saturday. Thank you so much. Bye.